Yes. Much obliged, my lord. Thank you.
Ahmednassir.
Yes, my lord. My lord, in my address to this honorable court this morning, I will be addressing 5 different issues. But before I do that, my lord, I would like to highlight 3 defining features that preceded this election, that defined this election of 8th August 2017. My lord, the first one, and this we capture in our affidavits, is that in 2016, as a prelude to this election, the 2 petitioners drew a line on the sand and said that unless the entire commission, which is the first and second respondents, are replaced, they will not participate in elections. And my lord, in compliance or acceding to that, the entire country acceded to that, and in January, the entire commission of the first and second respondent was shown the door on the insistence of the petitioners. My lord, emboldened by that victory, the first and second petitioners instigated a wide-range change in the law. The entire electoral law was as a result of that changed to their satisfaction. And my lord, the third phase is that they did a litigation on a scale. It was actually on an industrial scale, the litigation on an industrial scale, in which they litigated each and every aspect of the electoral law to ensure that the election is conducted as they demanded and required. For example, my lord, they litigated the Al-Ghurair printing. They litigated an allegation that the president will deploy the army. They litigated on KPMG and the audit of the report. They litigated on the alternative complementary system under Section 44. My lord, those 3 events show that the election of 8th August 2017 was done as the petitioners demanded. They were on the driving seat, my lord. My lord, having said that, let me address the 5 substantive issues I will address this honorable court. And my lord, the first one is, whereas Article 140 and 163, 3A of the Constitution provide both the jurisdictional and the procedural platform for invalidating a presidential election, where can this court find the substantive law to invalidate a presidential election? My lord, whereas Article 140 and 163, 3A of the Constitution provides both the procedural and the jurisdictional platform for this honorable court to invalidate a presidential election, where can you find the substantive law for invalidating a presidential election? Nobody has told you that, my lord. Not the petitioners, not the first and second respondents. And I will show you, my lord, that the only place you can find the substantive law to invalidate a presidential election is that you deconstruct Article 140, or what I call a reverse engineering of Article 140, and you will find the substantive law to invalidate a presidential election in Article 38, 2A. In other words, the only way you can invalidate the presidential election is to hold that the exercise Kenyans did on 8th August 2017, pursuant to Section 38, 2A, was invalid exercise.
Section or article?
Article 38, 2A. In other words, my lord, an entire presidential election is a negative invalidation of the right to exercise a political right under Article 38, 2A. My lord, the second issue I will address you on is in our local jurisprudence, what is the place of Raila Odinga versus IEPC 2013? The second, my lord, is in our local jurisprudence, what is the place of Raila Odinga versus IEBC 2013 case? And is there any need to revisit or depart from the various findings this honorable court made in that decision? My lords, the third issue I will address before this honorable court is the place of stare decisis and precedent in the electoral regime in this country, and in particular, my lord, whether interpretation of the Constitution is binding to this court, notwithstanding Article 163(7). In other words, my lord, can you depart from a constitutional interpretation, notwithstanding that the Constitution says that you can depart from your various decisions? My lord, I will draw a distinction when you interpret either a statute or a common law, and when you interpret the Constitution. And I will try to persuade you that when you interpret the Constitution, you may not depart from it in a subsequent decision, notwithstanding what Article 163(7) says. My lord, the fourth issue I will address you is what are the circumstances in which this court can invalidate a presidential election, on whose omissions and transgressions can this court invalidate a presidential election? And my lord, the answer to that may surprise many, and I will show you that in 99% of the cases, you can only invalidate a presidential election on the transgression of the voter who has exercised his will under Article 38(2)(1). It's only the transgression of the voter who has exercised his will under Article 38(1). Maybe 1% you can 1% is IEBC, if there's a transgression, 1%, because, my lord, this election I will show you, as I will show you, my lord, is all about the voter, the person who exercises his sovereign will. My lord, lastly, but not the least, and in a very, very summary and cursory manner, I will take you through the petition that's before the court. I will go through the structure of that petition. I will take you through the form, the substance, the pleadings, and I will show you, my lord, why I consider that petition a piece of science fiction. My lord, let me start with the first one. My lord, the first issue is an anchorage of a presidential petition in both its constitutional and doctrinal foundation. My lord, it's my humble submission, my lord, that an Article 140 just gives you the procedural platform. And my lord, Chief Justice, to the credit of this court, when you published the 2017 presidential petition rules, introduced Rule 8, which for the first time really sets out 5 grounds upon which a presidential election can be invalidated. And my lord, when you look at that and the petition, you will find that it's only ground 1 and ground 3 that this petition can be premised on. My lord, I say that Article 140 is a reverse engineering of Article 138. And why do I say that? Because, my lord, for this court to invalidate a presidential election, or for this court to appreciate that a presidential election petition has been brought out, we have to retrace our steps backward. And when we retrace our steps backward, my lord, you will find that it is the events of 8 August 2017, when 17 million Kenyans went to the polls, that brought about this result, or this court case. So it is the election, it is the exercise of the sovereign will of the people in casting their votes for their political leaders that has brought this event. So, my Lord, it is Article 38.2, that choice of Kenyans to decide who will be their leader, that brings about this election petition. It's not about the winning, or it's not about that the third respondent has been declared the winner that brings us here. No. My Lord, the winning of the third respondent is the consequence of the sovereign choice Kenyan voters made pursuant to Article 38.2. In fact, my Lord, the third respondent is a nominal respondent in this matter. This case is about the choice made by both the 8.2 million votes he got, the 6.4 million Raila got. That 15 million votes that was cast on 8 is what is being challenged in this court. The entire 15 million votes, the votes they cast, for the petitioners to succeed, this court must agree that those 15 million votes that were cast on 8 August don't count. It's not about whether IEBC officers signed some forms. It's not about whether President Uhuru did. It's not about all those things. It is about the 15 million votes. For you to overturn the decision, you must tell them that on 8 August, when you 15 million Kenyans came, you made some mistakes here and there, and we consider as a court that your votes will not count. That is the task you have, my Lord. So, my Lord, it's my humble submission, my Lord, that the court needs to undertake a paradigm shift on how an Article 40 petition is approached. And that, my Lord, you can only do by finding fault with the voter and say that your vote on that day does not count. So, my Lord, when this court is adjudicating of a presidential petition like it's doing this morning, under Article 40 petition, the fulcrum, the very foundation, the focal point is that we are dealing with the voter, not with any other person. And we are dealing with the voter on the premise that every citizen has the right to a free and fair election based on universal suffrage and the free expression of the will of the electors. My Lord, my learned friends referred, or my learned friends for the petitioner said that we are dealing with an Article 81. My Lord, if you look at even Article 81, which actually portrays the submission I'm making, Article 81 creates what I call hierarchy of principles. And it is not by accident, it's by design. That Article 81 starts with the electoral system shall comply with the following principles. A, freedom of citizens to exercise their political rights under Article 38. That is a fortification. It solidifies my submission that this actually is all about the voter who voted on 8 August. And that is why in this hierarchy of principles, we start with the freedom of citizens to exercise their political rights under Article 38. So, my Lord, we must never lose sight of the fact that this petitioner, the two petitioners, when they come to this court, they are challenging that right. And, my Lord, that's why I say this case is about a negative invalidation of a political right under Article 38. You must find, for you to invalidate this election, that Kenyans were not entitled to exercise their political right as they did in Article 38. In other words, that right So political right is what you are negating. It's not a case, my lord, of saying that President Uhuru Kenyatta was not elected. No, that's not what is before you. What is before you is you must find, for you to find that the election was not conducted, you must find that Kenyans, the 15 million who voted in August 8, were not entitled to exercise their political right under Article 38. And the honors, as I will show you later on, my lord, the burden of proof, even the standard has to shift, because the petitioner has to satisfy you that a person who exercises his right under Article 38 was not entitled to do. And that is the only way you can invalidate this election. So, my lord, and I said, my lord, that we need a paradigm shift. Previously, we used to see this as a gladiatorial contest between the winner and the loser. No, it's not. It's not a contest between Raila and it's not a contest between the petitioner and the third respondent. It may look nice for the public viewers that this is, a gladiatorial contest between the two big players. No. My lord, this is a right-centric dispute. It is a dispute that is centered on the political right of the individual. We need to shift, my lord, this from a contest of political supremacy and see that really what is at the substratum of a dispute in a presidential election is a right that was exercised. So, my lord, I pray that this court impresses a right-oriented approach, which is premised on Article 38, and not a result-oriented approach, which shows that the third respondent won this contest. And, my lord, that needs a lot of caution from this court. That's an argument, my lord. I will just plead that you hold it with, as Anton Scalia famously said, that some arguments you hold it with a belt and a suspender. Because a suspender may not be enough, or a belt may not be enough, although at times it's enough. But to be sure that it holds, you use both belt and a suspender, my lord. So, my lord, as I will show you later on, that it is very important that the approach you take, my lord, is not about whether IEBC did certain omissions or not in validating these elections. And, my lord, let me give you an example of, a typical Kenyan setting, a herdsman, for example, from Mandera, who doesn't even speak English or Swahili. He comes to a polling station. He votes with an assistance of one of the officials. He casts his vote. He may not understand the philosophical foundation of all these things, but he understands that he is making a choice. Then he walks out of that polling station and goes back to his cows or camels. My lord, can that choice of that herdsman somewhere in Mandera be invalidated because an officer did not stamp some of the forms when he filled it? Can we invalidate such a right? Can we invalidate such a basic foundation of that right, of an illiterate Kenyan who exercised his right, who walked out of a polling station? But because one of the agents of the candidates did not sign, we say, no, that man has not voted. My lord, that will be a travesty of justice, and that's not what this constitution is all about. My lord, let me go to the second point. What is the local place, or what is the place in our local jurisprudence of Raila Odinga versus IEBC 2013, my lord? My lord, to the credit of the court, and I have expressed many times my disagreement with this court on certain issues, especially its jurisdiction. But my lord, when it comes to our electoral law or the jurisprudence created by this court, especially starting with the Raila case, followed by Peter Munya case, Zakir Obado, Nadif Jama, and Kidero. This court has expanded the regime of electoral law like no other courts I know. You have solidified, you have settled the law, and the principles of election law in this country are so settled, so certain, so firm, that this court must be given credit for that. But my lord, in the Raila case, this court have addressed many issues, and it addressed it in a very, very proper manner, my lord. It settled the law on important subjects of the law, like the burden of proof, the standard of proof, rejected votes, and even the issue of judicial restraint. And my lord, yesterday one of my learned friends raised the issue of judicial restraint. But when I submitted on the issue of judicial restraint, it's not about the court abdicating it. Judicial restraint is not about the court abdicating or laying down its pen. No. Judicial restraint is the court following the law, exercising its jurisdiction as prescribed by the law. That's what I meant by judicial restraint, my lord. But my lord, Raila versus IEBC 2013 was unfairly attacked, not because of the jurisprudence espoused there, but because of the result the court reached. And that is natural because of the way the country was divided. 40-something% were not happy with it, 50-something% were happy with it, and that's natural. But my lord, the attack the court faced, from NGOs, or what my Lord Justice Ojwang used to call people who write in pamphlets, not in law review articles. I have not seen a critique of IEBC in a law review journal where you can agree. But there are so many pamphleteers, that's the word I think Justice Ojwang used to use. Or newspapers, my lord. People who write legal opinions. And one of the biggest critique of Raila versus IEBC was that the court relied on Nigerian authorities. So what? Nigeria is a superpower in all spheres of manifestation. It has 4 or 5 times our GDP. It has 4 or 5 times our population. I mean, Nigeria, my lord, is, even in terms of jurisprudence, we may have unflattering experience about Nigeria, but you can't ignore Nigeria, both in its economic setting or even its political setting. But my lord, it's my humble submission that Raila Odinga vs. IEBC 2013 is good law, my lord. You settled the law on all those issues. You did it in a very eloquent, beautiful manner. It's a case, my lord, that has been quoted many places, many jurisdictions. And my lord, it's a case you have subsequently validated it in Nadif Jama case, in Zakaria Obado's case, in Bitamunya's case, in Kidora's case. So my lord, it's actually what is called a solid rock precedent of this court. So my lord, in my humble submission, I see no reason why any of the issues you have raised in that judgment should be disturbed even for a moment. My lord, let me take you now to the issue of precedent. Why do I take you to the issue of precedent? Because there's a trilogy of cases by Peter Munya case, my lord, Nadif Jama case, and Zakaria Obado's case, where you have addressed these issues over and over again. The issue of the burden of proof, the issue of when does the court invalidate an electoral dispute, all those issues. And my lord, I want to persuade this court that since you have established the law on firm and solid ground, you don't need to deviate from that. You need to fortify it. And my lord, I don't want to go to the history of why this court, the Supreme Court, was established when Kenyans were agitating for constitutional reforms. But my lord, you will all appreciate, my lord, that because of the sorry state of the law in the 80s and 90s, where one court will decide the law this way, and the same court in the afternoon will decide the same issues differently. There was an agitation to have a Supreme Court which could create jurisprudential coherence, some solidity, some law and order. And my Lord, to the credit of this court, on most of those issues, there is that solidity you have created in the last 5 years. There is that soundiness you have created. But my Lord, I think I just forgot to highlight one thing in relation to the Raila case. Because my Lord, the court was conscious. If you look at paragraph 177 of that judgment, the court was conscious of the historic moment it faced at that point in time. And my Lord, if you look at that, the court, to its credit, delineated 6 issues why that judgment was of epochal significance. It was a very significant judgment. And the first one, my Lord, you said that although the law and the facts are not that heavy, you said that it is the first landmark case bearing on the early steps to consolidate the progressive and the unique constitution. The second issue you captured, my Lord, you said is that it shows the importance of the court in resolving disputes, even of the magnitude of a presidential election. And you go on. Third one, my Lord, you said is transition of the executive. There is the fourth one, my Lord, the cardinal role of the implementation. The fifth, my Lord, is you are alive to your duty as a Supreme Court to base the law on firm and solid foundation. That's what you said, my Lord, in paragraph 5 and 6. And my Lord, to the credit of the court, my Lord, I can attest that that judgment and subsequent decisions of the court have validated that. My Lord, I don't have to say this obvious, but stare decisis is not only the foundation of the common law tradition, but my Lord, it shows when a court follows stare decisis, it shows that the rule of law is well and alive in that country. When a court decides similar or same cases in a coherent and in a manner that is all same, it shows, my Lord, that that court adheres to the rule of law. And my Lord, when a court decides one case or 2 cases of similar facts differently, then you know that that court, there's chaos. And when there's chaos in the court, my Lord, there will be anarchy in the country. And my Lord, that brings me to Article 163(7), which says all courts other than the Supreme Court are bound by the decision of the Supreme Court. And my Lord, the fact that I don't think, my Lord, there is any country, to my knowledge, which makes adherence to a precedent a constitutional principle. This is one of the rare cases where the constitution of a country says, no, all courts must adhere or must follow the decision of the Supreme Court. And that underscores the problem I just highlighted. There was so much chaos in the jurisprudence of this country. The High Court could decide how it wants, the Court of Appeal could decide how it wants, that the drafters, if we can use that term, the drafters of the Constitution say, no, we must have a constitutional principle that says that all judges must adhere. It shows the enormity of the problem this country faced. But my Lord, can this court, when it interprets a constitution, when you interpret a constitution and you tell the country that this is what this constitutional provision means, can you depart from that? And my Lord, my humble submission is that you can't, notwithstanding Article 163(7), unless, my Lord, that the decision or the decision you have reached in that interpretation of the Constitution was so erroneous, so untenable, so unpersuasive, that you may be allowed to depart as an exception. But my Lord, because of the apex nature of this court, when you interpret the Constitution, you are telling Kenyans that this is what the law means. My Lord, if you change after 1 month and say that, no, this is what the Constitution means, people will not take this court seriously, and I'm glad you have not done that so far. My Lord, let me just briefly draw your kind attention to one or two authorities on this issue. And my Lord, the first one, my Lord, is a book written by two American law professors. It's Authority Number 6, Volume 2, supplementary list, my Lord. My Lord, if you look at from page 849, you will find a book written by Daniel Fapper and Susanna Sherry. The first one, my Lord, is a professor at the University of California, Berkeley Law School, and the second one is a professor at Vanderbilt University. The book is called Judgment Calls, Principles and Politics in Constitutional Law. Judgment Calls, Principle and Politics in Constitutional Law. And my Lord, the court talks about precedents, especially constitutional precedents, and it addresses the apex court. My Lord, I will just draw your attention to page 851, the last paragraph. Page 851, the last paragraph. Where the court talks of how does a continuing court, a court that continues like this one, address precedent. And then, my Lord, at 852, the paragraph, the third line, which starts with, in considering the importance of precedent, we must first consider relationship to the rule of law. I don't want to read, my Lord, but there's one page, my Lord, I would like to read, and that's page 857. My Lord, this is what the learned author says at page 857. They say, adherence to precedent does not mean simply refusing to overrule past decisions, but taking them seriously as a starting point for analysis in future cases. This is partly a matter of reasoning by analogy from similarities between the facts of cases, but more importantly, a matter of giving credence to the reasoning in an earlier question. The willingness of judges to defer in its own way to their predecessors and their expectation of a similar difference from their successors transforms courts from an ever-changing collection of individual judges to an institution, one which is capable of building a continuing body of law rather than merely a succession of one-time rulings. This kind of decision-making, which is familiar to students of common law, is structured enough to provide stability and coherence, but flexibility enough to allow improvisation and growth, creating a false dichotomy between precedent labelings such as unchangeable bedrock and others increase. So, my Lord, when a court is a continuing court, my Lord, it's always important to solidify precedent. If you change, for example, case law from one election cycle to another, then, my Lord, the court or the jurisprudence of the court will fall into disrepute. But, my Lord, page 860 is more profound even what the learned authors express in page 860. And this one, my Lord, refers to constitutional precedents. This is what the learned author says, my Lord, at page 860. They say, at least in certain kind of cases, precedent gets added importance in constitutional area. One purpose of having a written constitution is to create a stable framework for government. As even most originalists have recognized, this goal will be undermined if the court failed to give special credence to bedrock precedents that have become the foundation for large areas of important doctrines. Some obvious examples involve the ruling of the New Deal, upholding the validity of the social security system, and other federal taxing and spending programs, and those recognizing federal jurisdictions of the economy. This omelette cannot be scrambled today, as even the most devoted believers in originals often acknowledge. Likewise, it is far too late in the day to invalidate independent judges. My Lord, go to the second paragraph, which says, it is not simply that it will be imprudent to overrule those doctrines, though obviously it will. But in an important sense, It will run against the purpose of constitutionalism. Overruling these doctrines will create just the kind of uncertainty and instability that constitutions, even more than other laws, are designed to avoid. And my Lord, precedent, and I can say without any fear that Raila versus IEPC is a bedrock precedent. It provides the foundation of all other cases you have decided, and you should not depart from it. Lastly, my Lord, I will not read it, but look at the last paragraph in 861 and the next paragraph in 862. My Lord, let me go now to the fourth issue. When can a court invalidate a presidential election? When can a court invalidate a presidential election? And my Lord, as I said in my opening submission, in my humble submission, this court can only invalidate a presidential election if it finds fault with the voter. In other words, for you to invalidate the presidential election, cogent evidence must be shown. For example, that in the border town of Mandera, there were 20,000 foreigners who voted who are not entitled. Or in Busia, there were 30,000 Ugandans who came.
Very careful when you mention that county.
Yes, my Lord, I understand. Or my Lord, in the border town of Moyale, there were 40 Ethiopians who came, who voted but were not. It is only when you can be shown that voters or people who are not entitled to vote under Article 38(2) indeed voted. My Lord, the centrality of the voter or the Kenyan who exercises his political will under Article 38(2) cannot be emphasized. But my Lord, to show that that is really the point, and this court has actually even expressed those. I will show you, my Lord, that even though the court was not that explicit, there's a lot of inferences where this court have made in the Peter Munya case, where you say that it is Article 38(2) and the exercise that starts and ends with that can invalidate a presidential election. But first, my Lord, let me take you through the Canadian case of Ted to show you that even in developed democracies, the only or the major reason why courts invalidate elections is because voters who were not entitled to vote did indeed vote in that election. And my Lord, that you will find, that is the second authority in the supplementary list. It's at page 1 to 33. My Lord, I will not read, but let's start, my Lord, with page 48 of that decision. My Lord, page 48, I'll just draw you the introductory paragraphs 1 and 2. Then, my Lord, I will draw your attention to page 56. You will read at greater length when you retire. Page 56, my Lord, paragraph 23. Then, my Lord, if you look at page 57, paragraph 24, look at how the court defines irregularities that affects the result. And my Lord, the court said, and this is the Supreme Court of Canada, it says, this case involves interpreting the phrase irregularities that affected the result of the election. The phrase is composed of two elements, irregularities and affected the result. As we shall explain, irregularities are serious administrative errors that are capable of undermining the electoral process. The types of mistake, it goes on, my Lord. Then, my Lord, look at paragraph 25. It talks about affected results. Then, my Lord, at paragraph 27, look at paragraph 27. It shows what is the foundation of a democracy. It is the vote. But, my Lord, to show the centrality of the voter in any election, my Lord, kindly look at page 64. That's paragraph 44, paragraph 46. And my Lord, paragraph 50 and 51 now shows the point I've been emphasizing. Look at 50, my Lord, paragraph 50 at page 67. And my Lord, this captures the essence of the vote, the essence of the sovereign will as expressed in Article 38. Look at paragraph 50, my Lord, page 67. It says, the current system of election administration in Canada is not designed to achieve perfection, but to come as close to the ideal of enfranchising all entitled votes as possible. That's what an election is all about. It's about voting. It's about who votes. It's about who casts his vote. It's not about the technicality whether some results were transmitted from point A to point no. Why? My Lord, the foundation is vote. Have the voters voted? Have the right voters voted? And then it says, my Lord, since the system and the act are not designed for certainty alone, courts cannot demand perfect certainty. Rather, courts must be concerned with the integrity of the electoral system. This overreaching concern informs our interpretation of the phrase irregularities that affect results. And my Lord, just look at paragraph 51 of that judgment. My Lord, lastly, I will draw your kind attention to page 69, both paragraph 55 and paragraph 56. Then at page 70, paragraph 57. And my Lord, paragraph 57 is a gem. This is what the court says. The substantive approach is recommended by the fact that it focuses on the underlying right to vote, not merely on the procedure used to facilitate and protect the right. In our view, an approach that places a premium on substance is the approach to follow in determining whether there were irregularities that affected the result. On this approach, a judge should look at the whole of the evidence with a view to determining whether a person who was not entitled to vote voted, my Lord. And my Lord, that is the essence of an election. Did those who vote, were they entitled to vote? Lastly, my Lord, look at paragraph 58, paragraph 59, and paragraph 60, my Lord. My Lord, quickly, let me just take you through the local jurisprudence of this court. And my Lord, I will start with Opado, who was the governor of Migori. My Lord, in that case, the difference between the two was a mere 600 votes. And Professor Oyugi, who was challenging, had the simple task to show that despite all the issues he pleaded, Governor Opado had 600 votes that he was not entitled to, my Lord. My Lord, he could not prove that despite all the issues he says, some forms, some signatures were not signed, some polling stations opened late, the court told him, show us simply how we can deduct 600 votes so that we can call a by-election. And he couldn't show. My Lord, the same applies for Bitamunya. Bitamunya, Zakaria Opado, and Nadif. The difference between the winner and the runners-up was less than 1%. And in all those three cases, the court made one simple test. Numbers matter. Show us that the winner has certain numbers which he is not entitled to have. But my Lord, I think the most authoritative, the case you have addressed these issues most is the Peter Munya case. And I will just take you through that very quickly. My Lord, I will start at page 158. That case, my Lord, starts at page 158. But my Lord, to show the centrality of the voter under Article 38.2 is captured in paragraph 205A. You have acknowledged that, although you did not expound it, if you look at paragraph 250AA, this is what the court said, my Lord. It's at page 200 at the top. My Lord, this is what the court said. We will state as a principle of electoral law that an election is not to be annulled except on cogent and ascertained factual premise. This principle flows from the current democratic theme of the Constitution, which safeguards for citizens the freedom to make a political choice under Article 38(1), my Lord. My Lord, that's the foundation of a whole election. So when a choice has been made under Article 38(1) of the Constitution, for one to annul, you must find that there were certain mistakes that were done. My Lord, I will not read it, but I will kindly draw your attention to page 203, page 204 of that decision. And my Lord, all those three cases will show that the task the petitioner faces in nullifying an election is one of figures. Just show us how the figures you are complaining about can be annulled. My Lord, my last issue is the petition, my Lord, before this honorable court. My Lord, it's my humble submission that this petition is so my Lord, it's my humble submission that this petition, my Lord, pleads no course of action. No course of action. My Lord, even if you lower the standard of proof to be one below on a balance of probability, this petition will still be dismissed. Even if you lower, if you establish a new test that says that the test is one below a balance of probability, this election petition will still be dismissed. My Lord, even if the court will have dismissed that application and say that we expunge from the records all the pleadings filed by the first, second, and third respondents, and you allow the petitioner to prosecute this petition in our absence, it will still be dismissed. Yes. It will still be dismissed, my Lord. Because, my Lord, even without any defense, there is nothing they can prove in this, my Lord. It's allegation of rumors. It's allegation of political hyperbole. It says that the election was conducted so badly, and you don't give particulars. But my Lord, as my learned friend yesterday is rightly captured, and I say this, my Lord, when I was starting, this petition is a science fiction, my Lord. It's a science fiction which will only interest directors and actors in Hollywood. Because, my Lord, this petition is based on the theory that results that were being transmitted by the first and second respondents were intercepted by either aliens or extraterrestrial forces, changed it in favor of the third respondent. Don't explain why it was not changed on behalf of Dida or my friend Ekuru, but for the third respondent, manipulated at a frequency of 11%, and the third respondent won, my Lord, as a result of that. That is pure science fiction. It can't, it's so absurd that someone can put a chart there and say that the third respondent to win an election because a computer chip has been placed somewhere that manipulated the result that led to a result that the third respondent won the election. My Lord, when my learned friends from the IEBC said, leave alone about that, from the raw data on Form 34, A and B and C are there. Look at it and show us what difficulties you have. And my Lord, they had no answer to that. And my Lord, when they were supplied with those Form 34s, as required by the rules of this court, my learned friend, my Lord, Orengo said from the bar that they were photocopies, they were not original. The best evidence the petitioner has abused, my Lord, is those evidence by his lawyers. That is the best evidence they didn't. It's not by the petitioner and his witness in the affidavits, no. The best evidence, my Lord, is the one adduced by Orengo from the bench. But that itself is not enough to prove his case because it was hearsay. When he said, for example, that those Form 34s are not original, my Lord. Those are hearsays. That's not what a lawyer should say. So, my Lord, I have 20 more minutes. I will give to my learned friend. But, my Lord, I have shown that this petition is not a petition that is grounded in law. It's grounded on other grievances, my Lord. It's not law. It's not a cause of action. The figures and the numbers, my Lord, are clear. And, my Lord, for you to invalidate that presidential election, you have to show the bottom line, that the 14 million Kenyans who elected everybody else, and there is no quarrel about all the MPs, the MCS, the senators, the women representative. Nobody is unhappy about that. You have to show that those 14 people should not have voted, and they should not have voted in the manner they have voted, my Lord. My Lord, it's not the result one should be annoyed with, because in every contest there are winners and losers. No. You must have a bona fide, concrete cause of action for you to be aggrieved. The result is a natural consequence of Article 34(2). My Lord, unless you have any questions, that's the end of my submissions. I am most grateful, my Lord Chief Justice.
Thank you very much, Mr. Ahmednassir.